Major breaking news. Donald Trump has won his U.S. Supreme Court case involving whether or not he could be disqualified for engaging in insurrection under the 14th Amendment of the United States Constitution. As far back as early January of this year, I told you, and I told everyone on Fox News, this was not a strong case. Trump was definitely going to be on the ballot. The Supreme Court was not going to go along with the nonsense set forth by certain people to try to keep Donald Trump off the ballot under state laws. It was silly. It was basically a silly argument, and I'm happy to report that in a 9-0 per curium decision today by the United States Supreme Court, the views that I articulate on this channel, thanks to some scholars I relied upon, including Josh Blackman, the great professor down there in Texas. I'm happy to report Donald Trump has won this case. This was a slam dunk, gave rise to a lot of TV pundit talking about stuff, but at the end of the day, in the real world, this case was going nowhere. Donald Trump, big victory today. Let's talk about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of many books, including Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, I'm going to make this one quick. We don't have to belabor the point. Bottom line is, I explained to you that there was no way Donald Trump is going to be kept off the ballot by state attorney generals, by state secretary of states, or by state courts. Under the argument, or using the argument that under the 14th Amendment of the U.S. Constitution, which the 14th Amendment was adopted and ratified after the Civil War in the mid-19th century, using the argument that people that engage in insurrection could be denied the ability to hold a federal office. Well, today the United States Supreme Court came out with a per curiam decision, which is 9-0 in favor of the judgment, saying that Donald Trump was 100% right, that a state could not keep President Trump off the ballot under the 14th Amendment in any respect. It was a no-brainer. We talked about why this was a no-brainer. I gave you many reasons why this was never going to go anywhere, and that is exactly what happened today. So all I want to do today is I just want to give you a couple big points so you can be the smartest person in the room. And by the way, there was a lot of intellectual giants, constitutional attorneys, and other former judges that basically said that Trump should be disqualified under the 14th Amendment. And I said, guys, don't waste your time with that. That's nonsense, because remember, I'm here to teach you to be the smartest person in the room on these topics, and I don't care who else is in that room. I will make you smarter than they are. That is my goal, and I intend to, follow up and make that happen if I can at all possibly do that. And again, this is another example. If you articulate the views that I articulated on this channel, you would be 100% right and on the same side as the 9-0 Supreme Court today. So let's just briefly look at the big picture here. The bottom line was that the argument was raised by state courts and by state secretaries of states that had laws on the state books that says to sit on the ballot to be the President of the United States and to be voted for as a President of the United States candidate in various states like Colorado and Maine and so on. The person on the ballot had to comply with all relevant laws. The argument went that says that under the 14th Amendment, Section 3, that if you engage in insurrection against the United States or aided in abetting the foreign enemies of the United States in some way, you were not qualified to hold federal office. So the argument was raised in places like Maine and Colorado that says because Donald Trump engaged in and aided and abetted in an insurrection, a quote-unquote insurrection, absurd, but set that issue aside, on January 6th, he could be disqualified and not put on the ballot. That was the argument. This was silly for many reasons, and the U.S. Supreme Court explained big picture why that was the case today. Keep in mind that the Colorado Supreme Court and the Maine Secretary of State's office both said that, yeah, indeed, under the law, Donald Trump could be kept off the ballot, but I said that's not going to happen in the long run, and that's what's happened today. The Supreme Court has ruled exactly as I predicted. But the big picture is really not that hard to understand. Keep in mind that the whole purpose of the 14th Amendment was to restrict the authority, the legal authority or powers of states and localities to do certain things that before the Civil War they were allowed to do. This is why before the Civil War, for example, the Second Amendment's right to keep and bear arms applied only to the federal government. But after the enactment of the 14th Amendment in 1868, the Second Amendment and the rest of the Bill of Rights then apply to restrict the behaviors and the conduct and the powers of states and localities in addition to the federal government, which was restricted as of 1791. It also extended the Bill of Rights to other Americans, specifically the freed African American slaves. So think about that for a moment. The whole purpose of the 14th Amendment was to essentially expand, if you will, some powers of the federal government against state and local governments. And Chief Justice John Roberts and this opinion basically makes clear that it would be absurd to think that the 14th Amendment, which is about restricting and limiting the powers of states and local government, that somehow they would then have the power under that same constitutional provision to reach out and deprive federal office holders or people that wanted to become a federal senator or congressman or president, and that the state would have the authority and added control to prevent that from occurring. Essentially, Roberts and the Supreme Court says it's simply absurd to think that the 14th Amendment would actually give additional powers to the state government as opposed to limit it, which is the whole point of the 14th Amendment. And that is exactly what this opinion says, that the argument made against the Trump people was counterintuitive. It was actually arguing that the 14th Amendment expanded state powers when the reality was it limited. The other critical thing to understand here is that the Supreme Court said today, and there's a discussion as to whether or not they even needed to say this, but they did. They said that in their view, the only way a person could be disqualified from holding federal office pursuant to Section 3 of the 14th Amendment is if Congress were to enact some sort of law or were to make some sort of finding. Then Congress might have the authority to pass such a law depriving someone from serving in federal office because they engaged in insurrection. But the only agent, if you will, in the American system, other than we the people with our votes, of course, that can keep someone off the ballot would be Congress, is what the today's Supreme Court said. Now, I should just let you know one other thing that's kind of interesting here is that the court did not talk about whether or not January 6th was an insurrection, nor did they opine on whether or not the President of the United States is a federal officer under the 14th Amendment. They didn't even get into that. They just simply said that the 14th Amendment certainly does not allow states to take people off the ballot when they are running for federal election. At most, Congress might be able to do that. Congress never did it, at least as of now, and therefore it doesn't count. The only other interesting thing I want to flag for you here is there was a concurrence by Justice Amy Coney Barrett, and she really flags the notion that she was not a big fan of some of the added on views about whether or not Congress could take away the right of someone to run for office. She thought that the Supreme Court should have had a narrow holding that just says that the 14th Amendment doesn't say what the anti-Trumpers say it says, and Trump can be on the ballot, period, full stop. She did not think they should go on to talk about that Congress might have the authority to take someone off the federal ballot or to disqualify someone under Section 3 of the 14th Amendment. Specifically what Justice Barrett writes, and this is kind of interesting, she says, quote, "This is not the time to amplify disagreement with stridency. Particularly in this circumstance, writings on the court should turn the national temperature down, not up. All 9 justices agree on the outcome of this case. That is the message Americans should take home." Period. Close quote. That's what Justice Barrett said in a concurrence. Now, I'm not a big fan of what she just wrote there because it's a signal that she's paying attention to the national temperature or the national mood, which if you're applying the rule of law, those kind of considerations should simply not play a role. And the fact that Justice Barrett in that concurrence made that comment, I don't like that. I'm not saying it's catastrophic, but it's not smart because, again, it's indicating that people can put political pressure on the court and they're paying attention. And I think that's very, very bad for people who believe in the Constitution as it's written, including the Second Amendment, because that means that this court could be pressured by outside organizations and outside forces to get them to deviate from the Constitution as it's written, from the Constitution as it was understood by the Founding Fathers, and, of course, from the Second Amendment. Not that this case deals with the Second Amendment specifically, but it is very telling that Justice Barrett made that comment. I'm not thrilled that she did so. I don't think it's necessarily catastrophic. This may just be a marginal criticism of an intellectual geek here dealing with the court and the Supreme Court on a daily basis, but I am just flagging this one point. I'm not a big fan of what she wrote there, although it will likely get quoted throughout all the papers and in the press. But nevertheless, that's what was written in the concurrence by Justice Barrett. But none of this affects the outcome, which is 9-0 per curium decision for the entire court, that Donald Trump will be on the ballot in all those states for the 2024 presidential election. And then as to what happens, that's up to we the people, and of course the process by which these votes are counted. But that'll be a topic for another day. So there you have it, folks. Hope you learned something here today. I'm glad I was right on this prediction, both here and on Fox News repeatedly. I knew I was right, pretty confident of it, and I'm glad it proved to be true. So there you have it. Don't forget to follow me on X at 4boxesdiner and subscribe and resubscribe to this channel. Make sure you don't get knocked off by mistake. And we will see you again soon here, yes indeed, at the 4 Boxes Diner.
Orders up. Table 2A.